start. My name is John Giles. I'm one of the attorneys at Michalsons that assists organizations with data protection and access to information. And then from Michalsons, we've also got Mark Hank, who is one of our attorneys. Mark, you're on mute, I think.
Sorry, I thought I had unmuted myself, but nice to be with you. And I think 2022 could be quite an exciting year for all of us. So let's get to it.
Great. And then we've got Nathan Ross Adams, also one of the attorneys at Michalsons.
Hi, good morning, everyone. Looking forward to today and discussing our plans for 2022 with the regulator. If it's anything like 2021, it's going to be twice as exciting.
Yes, definitely. And then we've got Zwakele Mbanjwa, who's one of the attorneys at Michalsons, and he's the facilitator for today, really trying to coordinate the questions.
Hello, everyone. I don't know if it's still safe to say compliments or Happy New Year, but Happy New Year to all of you. I'm looking forward to having this conversation and excited for the year coming up ahead.
Fantastic, thanks. And I see there are a few chats in the chat boxes already. Please put messages in the chat box, but when it comes to the questions, let's use the Q&A functionality. What we've enabled is for you to add your questions there. You can also read other people's questions, and you can upvote questions that you think are really important. And I think it'll be a good way for us to make sure we answer the key questions that you have today. So let's use that functionality, and Zwakele will be watching that box very closely. And then we're very pleased to have with us two members from the Information Regulator, or two representatives. Firstly, we've got Mrs. Alison Tilley, who is one of the members of the Information Regulator. And Alison doesn't really need any introduction. It's fantastic to have you with us, and thank you very much for your time.
It's a great pleasure to join everybody. Thank you very much for setting this up. It's always a great opportunity to talk to colleagues and friends, and I think we can still say Happy New Year. I plan to keep doing that for at least another week. So Happy New Year.
Thanks, Alison. Yeah, and then we've got Mr. Mukalani Dimba from the Information Regulator, who's the Executive for Education and Communications. And it's fantastic. I've watched you on many webinars before, and it's fantastic to have you with us today.
Thank you so much, John, and good morning, everybody. Such a fantastic opportunity to have this conversation with you all this morning. And Nathan, I hope that 2022 is nothing like 2021, at least from the perspective of the Information Regulator. Certainly, we would like things to be a bit more boring this year. Thank you.
Yeah, so 2021 was a frantic year for data protection and access to information. And I know the regulator worked extremely hard. I think all of us did. And I know for Michalsons, we had a very busy year, and our clients did too. There was a lot that happened. And I think that's a good segue into really what today is all about. Is we thought we'd, at the beginning of this year, look back at last year and look at some of the highlights as a panel, and then look forward to 2022 and see what the year will bring for us. What are the key milestones or issues that you as an audience and organization should be thinking about and planning for? Because if 2021 was the beginning of the journey, the birth of POPIA, the adoption of PAIA, 2022 is really where we've got to start growing up. We've got to operationalize these different laws. We've really got to give effect to these fundamental human rights. And that's really the intention of today, is as this panel is to discuss that and to get your feedback, your thoughts that can be in the chat or ask your questions in the Q&A. And let's really have a discussion about it so that we can really make 2022 a very effective year. I think it's a good time to have this event because, as many of you will be aware, there were three of the members of the Information Regulator were reappointed in December for another 5-year term, and one new member was appointed in December as well. So We now have the members of the regulator who are going to be there for a while, and it's a good time then to look forward even to 5 years to see what some of the regulators' priorities are. All right, we're going to dive in just now, but what I thought we could do is get a better idea of you as the audience. So I want to run about 3 snap polls really quickly. So please be quick with your fingers. The first question is, how many employees does your organization have? It's always useful to know roughly how big the organizations are that are on the call. It helps us make sure that the content is specific to you. You're doing great. Sure. You're 80% have voted. So let's leave it there. And I'll share the results quickly. So most of you are large organizations, which is really interesting. Mainly, medium to large. Then the next question, and please feel free to be honest here. It is anonymous, so we won't know who answered what, and the regulator is on the call. But we wanted to get an idea of what's your level of awareness. How well do you know these topics, and where should we be pitching this discussion today? Fantastic, the answers are coming in. Right, let's end it there. I think that's a good representation. So most of you know it well enough for your purposes. 30% know it well, which is fantastic. So it's an educated audience, which is great. Then let's look at data protection compliance. So how much work has your organization done on data protection? Let's get a feel, and it is anonymous again, so please, you could be honest. But, I don't think there's anyone who can put up their hand and say they fully comply. Most people are working towards compliance, but it's interesting to see roughly where you think your organization is at. All right, I think let's leave that one there. So most of you saying you've done a reasonable amount focusing on the high-risk items. You'll know we've often spoken about doing what's reasonably practicable. And that's interesting, but 40% are saying you've done a lot and you think you comply, which is fantastic as well. It's really good to see that. And then let's lastly look at access to information and look at PAIA, and how much has your organization done for PAIA? As I mentioned, the regulator adopted it in the course of last year from the South African Human Rights Commission. And I think this is going to be a significant issue going forward. All right, thanks for being so quick with your fingers there and voting. So it's roughly the same as the previous vote, which is great. And I'm really impressed that there's such a high percentage of people that think they've pretty much done what's necessary for compliance, which is fantastic. Great, so I think the last housekeeping issue is that we are recording the session and it will be available to those who'd like it. But I think without further ado, let's hand over to Alison to take us through her thoughts.
That's great. Thank you so much. What I want to do is just talk a little bit to where the regulator finds itself. And as you say, last year was rather too interesting in that regard. And then talk a little bit about what the current areas are where I really feel we have not been able to explain clearly enough what it is that people are needing to do. And I'm in particularly want to talk about codes of conduct and prior authorization, because I think those are 2 areas where I see a lot of really wrong thinking about what those are all about. We've also been given some questions which we've had a look at, and I'll be able to speak to those. So I'll kick off with those issues. As you'll know, the regulator's powers have kicked in terms of POPIA at the middle of last year. And the regulator also took over the mandate from the South African Human Rights Commission in relation to access to information. So it's been a bit of a ride, a wild ride, one might say. And I think particularly the thing that frustrated everybody was the registration of information officers. And I think that that was an area where we really found we had some major challenges. The regulator is still functioning as part of the Department of Justice. And we are hosted, so to speak, were hosted by the Department of Justice. And I think you will know the issues that the department ran into towards the end of last year, which just compounded our difficulties. And so I think we need to say upfront that that was one of the major challenges in last year, and we've really had to rely on old-fashioned email and sending in the registration application on email rather than using the portal as we had hoped to. I think secondly, there's been a lot of discussion about prior authorization. And I think when I became worried about prior authorization, I think it was an application by a tour guide company that organized birdwatching tours, and that they wanted prior authorization for the processing that they're going to do. And it just couldn't have been more inappropriate for an organization like that processing that level of information. It just was completely wrong. And I think the regulator is going to need to work harder to make it clear what prior authorization means. Now, if we just go back to the history a little bit, I was part of the Law Reform Commission dealing with this issue, and we had, although once we decided that the European Union was to be sort of the main touchstone in terms of us drafting our legislation, we still have differences within the EU. And the example that we were looking at was France, which has a very big privacy agency. And the French approach was basically, if you're going to be processing personal information, you need to notify the regulator. And we were painfully aware that that was not going to be an option in South Africa, that the regulator was never going to be big enough. And we certainly weren't at anything like the level of maturity in the area of data protection to require everybody to notify if they're going to process personal information. However, it did seem that there were going to be instances where people are going to process personal information where there might be particular risks. And if those risks exist, then in those circumstances, it would be a good idea to notify the regulator. And there was born the idea of prior authorization. So where you're doing something, and the Section 57 describes in detail what it is that we regarded as particularly concerning. But essentially, we're not asking for you to upfront tell the regulator everything that you're going to do, but there are certain circumstances where you want to do that. Now, prior authorization is not a get out of jail free card. It's not where you say to the regulator, listen, I may do something wrong in relation to POPIA, but it's really important. The information that I'm processing, the reasons I'm processing it are very important. So what I want you to do is give me now, through the vehicle of prior authorization, the assurance that if I do something that isn't in line with POPIA, that I won't get into trouble. And that's not really the purpose at all for Section 57. And I think it's really come up again and again where people are saying, yes, but I'm going to do this and it might breach POPIA. Well, then the answer is don't breach POPIA. The answer isn't to apply for prior authorization. And it concerns me that people are getting the kind of advice or simply making a wrong assumption about what prior authorization means. And I certainly think that we as the regulator have noted it as a problem in terms of education and communication, which is one of the areas I'm responsible for. And we really want to spend some time trying to explain to people why this section is there and what it's there to do. So I think that's one area that I think we need to look at. I think the other thing that I've seen a lot of applications that are just not well founded at all is looking at codes of conduct. And the difficulty seems to be that people imagine that everybody needs a code of conduct. I don't really understand the thinking, but we will have applications from individual companies that represent nobody else and that are not parts of any collective, for want of a better word, and who are asking if they can have a code of conduct. I think, again, maybe the thinking is that, well, if I have a code of conduct, then in some way, if I process information incorrectly, maybe I get some kind of, is that an open door that I can then go through and, I won't get into trouble. But again, no, I mean, a code of conduct were thought of in this way. When you have processing of personal information, that's happening across many different industries, right? Many different sectors, people who have different interests. And we took the view that there was going to be a need to individualize the regulations in relation to each sector, and that the sector themselves would be the best placed people to describe how that should work. So if you're part of the banking sector, you should have a code of conduct that applies to you, which would be drafted with your peers, with your colleagues. And the idea is that you would then be able to draft something that would line you up with everybody else, and you would then be able to proceed in terms of that code. Now, the difficulty, I think, for people has been that they haven't quite understood that. So we will have people who are individual companies, don't represent anybody, and they are applying for a code of conduct. And that's obviously completely wrong. You're applying for a code of conduct because you represent a group of people in your sector. One of the things you do have to show is that you do in fact represent them. I mean, it's not that if there are 100 organizations in your sector and you have an organization that represents 10 of them, you're going to struggle to persuade the regulator that you do actually represent the sector. So that's one of the key things going in, is that it's a question of fact. Do you represent the sector that you're in? And we've taken a fairly a view that's really probably, well, that's the view we've taken now, that we're looking at a similar calculation as you'd find in the Companies Act. So 50+1, and you're not going to count a bigger company as 2 and a smaller company as -2. They're going to be counted as 1, each one, for the purposes of that calculation. So those things being said, let me perhaps turn to some of the questions that we've been asked, and some of them, I think the answers are reasonably straightforward. So, will we, as a regulator, extend the deadline for prior authorization? And the answer is that at this stage, and bearing in mind that it is the middle of January, our answer is no. We think we are going to deal with the applications that we have, and we do think we will respond to the applications that we've had sent in timeously. Obviously, that means not, so for example, if you sent in an application in January, you can't expect that it's going to be dealt with by the 1st of February. So bearing that in mind. We've also been asked the question about adequacy and which jurisdictions outside of South Africa we would regard as providing adequate protection. And we haven't provided a list, and we are not in a position to publish a list now. If there is a complaint about a transfer of data to a country, and the complaint is that the protections in that country are not adequate, we would have to deal with that as a priority, obviously. There is a discussion about how to reach a list of countries that would be adequate. I think there are 189 jurisdictions across the world. We would have to, in all likelihood, focus on some of the bigger trading partners for South Africa. But as I say, we don't have a list at this stage. If there is transfer now of special personal information to a country that doesn't have adequate protection, then indeed you would need to look at prior authorization. On the question of registering information officers, as I indicated, our portal has not been what we hoped it would be, and we would need people to continue to email their registrations in. Interesting question that was put to us, whether the regulator would fine a responsible party this year. I would perhaps turn the question around and say, on what basis would the regulator, who is a creature of statute, not be able to not exercise its powers in terms of the Act? And we're not a court. We can't, well, a high court anyway. We can't. We don't have inherent jurisdiction. We can't change our own rules. When the legislation comes into operation and the law comes into operation, the regulator is then responsible for making sure that people comply with the law. So I think that's the answer to a number of questions, really, in terms of delay and, you know, and what the regulator's view will be. In terms of having a PAIA manual, there was a question about whether or not people would be held accountable for not having a PAIA manual. But given that the provisions for having a PAIA manual have been in place for 20 years, I think it's quite reasonable to ask people to have a PAIA manual and to hold them accountable if they don't. In terms of whether or not people should have, when people should conduct a personal information impact assessment, I think the answer is you should have done it already. And I think people shouldn't get too exercised about what that means. I think it means that you have to sit down and look at the personal information that you have and how you're processing it, and, you know, whether or not you're keeping it up to date, and when you don't need it anymore, are you destroying it? And if you've done that properly with all the personal information that you have, then, you know, that should be fine. Last question, really around the GDPR and saying, look, they have similar language, and of course that's quite right. Our legislation was based on the GDPR. Forgive me, not on the GDPR, but our legislation was based on the European directive. And of course, the GDPR is a further iteration of that. It may well be that the two continue to diverge. So in other words, POPIA remains the same and the GDPR continues to change. You have to look at POPIA. I think that the guidance, and you know, we've certainly had this discussion about how POPIA will be implemented. I mean, it is useful to be able to look at other jurisdictions, and I would certainly look at the European Union as a better example of a comparative jurisdiction, but it really is comparative. It's not the same, and the wording is not the same. The concepts are not the same. So I think you always have to go back look at POPIA and its definitions. Those are the important things to look at. In terms of transfer impact assessments, same answer. I think that we would be foolish to ignore the Schrems decision, and I think that does give us some clear guidance in terms of the American state of privacy legislation. But it's not our decision. It's not the decision of our courts. It is the decision of a court in a different jurisdiction with a different law. So it's while it might be useful, I don't think it's helpful to regard it as determinative. So in terms of issues that have come up so far and questions that we have to answer, that is what we have so far. But I would be very happy to take further questions, and before I finish, if I can just ask my colleague, Mr. Dumba, if there is anything that he would like to add on those issues.
Thanks, Alison. I think you've covered a lot of ground there. I just wanted to speak on the issue of PAIA manuals. The question whether there was going to be another extension or exemption on the production of PAIA manuals. The answer is correct. The answer is no. And I just need to remind colleagues that we've been on this issue of PAIA manuals since 2003. If I remember, that was the first extension that was granted by the Minister of Justice on the production of PAIA manuals. The last big one was in 2011. So, I mean, I think holders of information have had a fair amount of time to get their houses in order in terms of PAIA manuals. So we will this year begin to conduct assessments to look into whether or not this provision is being complied with. Yeah, thanks. That's what I wanted to add. Thank you.
Thank you very much to both of you. It's fantastic insights and really interesting to hear your views. I think you covered a lot in a very short period of time, and I think it demonstrates really the size of the task ahead of the Information Regulator and of responsible parties to do many things. And certainly you touched on issues that are definitely on my list for this year. For those of you who don't know, 1 January was 2022, so what's it, 13 days ago was the deadline to have a PAIA manual. You need to have one now. 1 February is the deadline for prior authorization, so that's a key milestone this year. And then, Alison, I totally agree with you on codes of conduct. I think many people have applied for them incorrectly or without needing to. And also to echo what you're saying about prior authorization, it's essentially where a responsible party is processing personal data that has a high risk implication to data subjects. That's where you should be getting prior authorization from the Information Regulator. And maybe just to add, I saw there were some questions, or there lots of questions and comments. There's lots of information on the Michalsons website to help you to get a PAIA manual in place. The regulators released a template. Michalsons, we've also released templates. So there's lots of information available that can help you to quickly and easily comply with those requirements. There's also lots of information on the Michalsons website about prior authorization and when you should apply and how you should apply. And so there's lots of assistance for you there on those topics. But I think let's now go to other members of the panel, and maybe if we can go to Mark Hank and ask you, Mark, also, what do you think the main outcomes or highlights were of 2021, and what do you see happening in 2022?
Well, I think the main thing was just simply the fact that POPIA was implemented led to greater awareness of the responsibilities generally of just protecting personal information, constitutional right, which in many instances has been neglected in South Africa by a large number of parties that were processing volumes of information. And of course, that neglect has led to the ability of cyber criminals, because personal information is a raw material. And that's not the only thing that we're trying to protect against, but certainly South Africa has been subjected to significant cyber attacks. And one of the reasons for that is the lack of protection of personal information. I think crucially for business, one of the things that it also created a focus on was that the importance of just governance and management of information, as we've changed and pretty rapidly when one thinks about it, from processing information in physical form into the way that we work today and the different media that we work in. And I mean, even in the last 2 years with COVID, the manner in which we work has changed significantly, and the manner in which we need to govern and manage information is something that we do have to requires quite a bit of focus and attention to how we might change that. I think the other thing is just simply that I now see, and probably it was only from last year that we started seeing data subjects themselves appreciating their right of privacy and the importance of holding people who are processing their information properly accountable. Possibly not to the extent that we would like, but that is part of what will happen. And it will be that type of realization that will drive a lot of what we see in the marketplace insofar as how companies and processors of personal information deal with it. In my view, if you deal with it well as a business, that is going to become a competitive edge, as has been shown in other jurisdictions. You deal with it badly, there's a high level of reputational risk that you run. I think that one of the other things that was highlighted through 2021, for years we've been sweeping data breaches, and because of the work that I do, I know of many data breaches that simply were swept under the carpet and nobody knew about them because that was comfortable for companies to do so. Obviously, data breach notification has changed that landscape, and suddenly people are asking, oh, there are lots of data breaches. Probably there might be more, but they're not significantly more, but we are knowing about them, and that is important because that judgment in the eyes of public opinion of those parties who are not protecting personal information will lead to companies and other big processes of information investing properly in information security. Insofar as this coming year is concerned, for me, one of the focuses will be information security. There's a saying attributed to a chap called Thomas Shaw, who wrote a book on privacy and information security. And he says you can have information security without considering privacy, but you can't have privacy without considering information security. And that is so correct. And a lot of the information security disciplines that have been developed are as a result of data protection. And that's where the rubber is going to hit the road and the things that we've got to do. And I see that there will be quite a lot of focus on the interconnectivity between data protection and privacy in this coming year, and the alignment with what companies have to do. I think that one of the things that is very important is, as well, is the fact that the regulator now has the responsibility for PAIA. We have known for many years that there's been huge delinquency around requests for access to information. And that certainly suited many organizations, and particularly government was one of the areas of greatest delinquency. And certainly, one of the things that we must take into account is that the information that led to the downfall of Jacob Zuma and what we now know from the state capture report as the malfeasance in that regard was not because of access to information. That was leaked information. And we have a right constitutionally to know what is happening and how, not just information, but how funds are being used, etc. And I believe that the the importance of that now being brought into the remit of the Information Regulator, and particularly with somebody like Alison, who knows both sides of that story very well, dealing with PAIA to a large degree, cannot be underestimated. So again, I would join you in thanking Alison and Michalsons in what they've told us. Obviously, we can't cover everything in the time that we have, but there are important questions, and the fact that their attitude to education and making sure people do understand what their rights are and what their obligations are in terms of POPIA is extremely refreshing. Thank you, both of you. Thanks, John.
Thanks, Mark. That's very, very insightful. So next I'd like to go to Nathan Ross Adams, one of our attorneys, and Nathan Ross is very good at monitoring social media. He's got his finger on the pulse, so he often is the man who can spot trends from a global perspective and translate that into a South African perspective. So Nathan, over to you to get your insights.
Perfect. Thank you very much, John, and thank you very much, everyone. Yeah, I wanted to start off by saying that one of the things I really enjoyed about the regulator's involvement, well, last year specifically, was the fact that there was a lot of stakeholder awareness, and it was publicized widely on social media. And as a result of that, the words POPIA and PAIA started to trend on platforms like Twitter and LinkedIn, which is very important because although we mainly deal with big organizations on a daily basis, for people to actually understand how their rights work and how it actually matters, they actually have to get on the ground, or the regulator has to get on the ground and do these campaigns, and they've done that successfully. So I think that was really important. But moving along to 2022, I think it's about making privacy and access to information real and tangible for South Africa. I mean, for me, at least, two themes that are going to be prevalent this year is going to be corporate governance as it relates to data protection and data privacy, as well as balancing data rights. And we can see some examples of this coming real already. So for example, one of the examples that I see someone's mentioned in the chat was the example of the matric results that will no longer be published in public newspapers. There are education rights that are being balanced against privacy as well as access to information. And it seems that privacy has taken the lead over here, or the scales have tipped in favor of privacy, which is very interesting to see. Then another point was that there have been a lot of questions that people have been asking about what's happening with the contact tracing databases that have happened, that have been recorded because of the COVID-19 pandemic's contact tracing, as well as the national identity system that Home Affairs, or their plan for it, which they just released, to have a single repository of the data of South African citizens as well as biometric data. So I think there will be a lot of academic argument about that, but it's important that everyone gets to know about these issues because they impact them on a day-to-day basis. And then interesting as well was that there was a case which was decided 2 days ago. I think it was called the Smuts versus Botha case, where it related to privacy rights, public personal information, as well as social media. And what had happened was someone had taken a lobbyist had taken pictures of a dead baboon and porcupine on someone's farm, and in the High Court, it was decided that, well, an interdict was granted against this lobbyist for posting the information on social media, but the SCA overturned that decision because they said that in that case, freedom of expression weighs more than privacy. So we're facing a lot of these issues in 2022, and that's why I said I'm actually looking forward to 2022 because we're going to be tackling a lot of these things, and it's very interesting. But from a corporate governance perspective, my interest is in, as John and Mark and Swakele would probably know, is a lot in emerging technologies and how these emerging technologies will challenge POPIA and will challenge organizations in how they deal with data privacy. So IT governance, data governance has become more important. Yes, it considers data as a whole in an organization, but POPIA plays a big role in that. For example, if you consider credit organizations that process credit data, and they use algorithms to process that. There are many POPIA considerations for that, but there'll also be a lot of talk about emerging technologies as it relates to the metaverse, as you've probably heard Mark Zuckerberg talk about quite a bit. But yeah, I'm really looking forward to this year. I'm looking forward to engaging more with different people and the regulators specifically on how they are going to be approaching these issues. My expectation is not that there'll be immediate answers to everything, but I'm happy that we are at least having this conversation, because it's a great start to a great year, and I'm looking forward to how it's going to turn out. Thanks, John.
Thanks very much for those insights. They're very interesting. And maybe to pick up on something that many of you have been mentioning, and for me, which is a theme, is that if you look at data protection and access to information from a global perspective, as South Africa, we're doing quite well. There are many countries that are ahead of us, but there are many that are behind us. And so this year, China, well, at the end of last year, China enacted a data protection law. India is in the process of enacting one. The United States is far behind in doing it. But if you look at different countries, there for me is a trend. It starts with the formulation of law, the enactment of the law, and then there are teething problems on all sides. The authorities all around the world, it's difficult to set up an authority that is going to deal with these issues. It's difficult for controllers or responsible parties to do what they need to do. And there is a lot that they need to do. It's a significant undertaking to protect personal information, and it's a never-ending task. And so there's always a teething period where there are problems, but then it settles into more mature situation, and we start seeing really interesting application of the principles to real problems, like what Nathan Ross has been raising and talking about. And we do start seeing then authorities taking action and issuing fines and holding people accountable and responsible for what they're doing. And so I think in South Africa, for me, we're heading into that period now. We've got through many of the teething problems. We're heading into the period now of really starting to hold people responsible and accountable for ensuring that these issues get addressed. All right, before we go to questions, anyone from the panel want to respond to anything that's been said or to add? Okay, yes, Mr. Dimber.
Thank you so much, John. Now, Mark mentioned something quite critical with regards to data breaches, or what we call security compromises. It is a major concern for the regulator. I think at the last count, we've had about 139 being reported to us in terms of Section 22 of POPIA. I would say about on average, there's about 10 that happen that we become aware of, whether or not they are reported. So it's a major concern, and it's something that the regulator is going to prioritize for the next coming years. Soon we will be launching or introducing some kind of internal restructuring within the division to have a designated data breaches unit that will be looking into these issues, because these data breaches, it's not just an event that happens once. The one big data breach that happened in 2020, in August 2020, we are still seeing repercussions of that even today, because some of the data keeps on emerging on various platforms. It gets removed from one platform, it emerges on another. So there is a responsibility, a pressing responsibility on the responsible parties to begin to put in place mechanisms that will safeguard the information that they hold. And we will be looking into that. We will want to make sure that where data breaches occur, there is action, effective action taken by the responsible party as well as the information regulator. So I just wanted to emphasize that point, that it's an emerging trend, and it's something that we are keeping a very close eye on. Thank you, John.
Thanks very much. All right, I think let's move into the Q&A section of today. We've got about 15 minutes to answer some of your questions. We're not going to get to all of them, but we will pass on all the questions to the regulator, and they can try and help to answer those questions. We also will try and answer them through the Michalsons website. The other thing to mention is that this is a public session that we're doing today. Next week, Wednesday, we're holding a session just for the members of our data protection program. And we're going to be discussing the data protection road ahead and really workshopping many of the issues we've spoken about today, and really trying to help the members of the program plan what they should be focusing on for the next 12 months. But let's go to the questions. And it looks like thanks for voting. It looks like we've got some that are filtered to the top. Over to you, Zwakele.
Thank you, John. I've got a task, a hard task ahead of me. There's so many questions, about 35 here, and I think the general theme is around registrations. So how do they? I think troubleshooting around registrations. The theme is around information officers. People are asking whether they need one, don't need one, who needs one. It's around manuals. For PAIA, there's prior authorization questions and all of that. So I think, and also there's some security questions as well. And just to pick up off of what you, excuse me, the thoughts that you had around the security compromises there, Mugilani. Is there a dedicated email address? People are asking, is there a dedicated email address that can send breaches to? And whilst you're on there, related but not quite related, and this is open to the whole panel, what's the intersection you guys are seeing between the Cybercrimes Act, POPIA, and what does the audience need to be aware of within that frame?
Well, let me take the easy one. I'll leave the difficult one for people that have been involved in drafting both the Cybercrimes Act and POPIA, that looking at market analysis. I've just put on the chat or the Q&A box the email address for data breaches. It's a simple one. It's dataBreaches@inforegulator.org.za. Thank you, Zwakele.
Thanks, Mugilani. Mark and Alison, the difficult ones are for you.
I'll start, and I think that the important thing here is to just recognize that part of what happens in any revolution, and we've been in an information revolution, is that there are certain things that the law previously did not actually address properly, or if it addressed it, it addressed it in a manner that needs to be reconsidered, considering the technologies and the applications of the time. Our law evolves continuously, and what we are seeing now is that we're in a period where the law probably is lagging significantly behind social and commercial developments, and certainly is behind what has happened in the criminal world, insofar as making sure that we have the right tools to be able to prosecute the criminals. And this is not a new phenomenon. I mean, in the United States, it was well known that there was racketeering and the mafia were doing bad things for many, many years. But it took quite a lot of effort, and it took time to put into place their RICO Act to be able to address those issues and bring to book the leaders who insulated themselves from the way that crimes could be prosecuted. So I think that's quite important, that you've got to look at both of them. They address things from a different perspective, and remember that the focus of data protection is on the protection of personal information. But we must recognize as well that personal information, and it has been shown in jurisdictions around the world, the better the protection of personal information, the more difficult it is for cyber criminals to do what they want to do. And therefore, the protection of that raw material for the crime itself is a critically important thing. So one needs to understand the two, but also understand the differences and the different purpose of both of those acts. They are very different, but most organizations should look at them carefully and make sure that they are able to protect themselves properly in this day and age. I don't know whether Alison would like to add anything to what I've said.
I think just to say that the regulator is not the cybercrimes cop. What we are looking for, I think, is for a serious initiative on the part of SAPS to really build their capacity to deal with cybercrime as a crime. And without that, I think we are going to continue to see cybercrime. And I mean, if you just look at the context in the country, the levels of unemployment that we see, the levels of poverty, I can only see cybercrime being more and more of a feature. And I think if I were concerned about my clients being able to lay a criminal charge around a cybercrime, I think that the capacity within SAPS is weak, and there needs to be significant effort persuading SAPS and frankly doing the work, going in and helping them build skills, because that is something that just I think they're woefully undercapacitated.
Mm-hmm. Thank you, Alison. And just before I go to you, John, I think I'll pose this to you and also ask the other panel members to join in, is the question around the grounds of justification. So there's this idea that consent is almost the only ground that people can rely on as a ground. And I just, if you guys can, John, maybe, start the conversation around where's the confusion, and why do people think it's only consent? And is that even true?
Yeah, sure. In order to process personal data, you need to have a lawful ground for processing. And there are 6 grounds, consent being one of them. And many people make the mistake thinking that I have to have the data subject's consent in order to process their personal information. And that's not the case. But often it's useful to get consent. So you might get consent from your employees, you might get consent from certain customers, but it's not consent-driven our law. And I've certainly seen many people make the mistake of trying to get consent when they don't need to, and there are many other ways of processing using some of the other lawful grounds for processing. But maybe, Zwakele, while I've got the mic, if I can just go back to 2 of the issues that we were discussing. The one is on the portal for the registration of information officers. I read somewhere that the regulator is hoping that by March it will be back up and running. I'm not sure if that's accurate, but my understanding is that in the meantime, you should be emailing those applications to the regulator and they'll be processed that way. And then the second issue's gone out of my mind. Yeah, so let me go back to you, Zwakele.
No problem. I guess just on that theme around the grounds, Mark, there's a question there from Raphael around legitimate interest as well. Do you want to just maybe touch on it and just continue the conversation around these grounds, because they are a topical issue here. I think you're on mute.
Sorry, the question that was asked by Raphael Hoffman was whether in the context of section 11(1)(f), it's different from GDPR. And because we don't have those grounds where in GDPR you speak specifically of the fundamental rights of individuals. Now, I don't know whether Alison will recall this, but when we were discussing this at the South African Law Reform Commission, the issue came up, and one of the things that was mentioned was, should we not add on all the constitutional rights of citizens? And Judge Howie was the chairman of our committee, and at that stage, the president of the South African, sorry, not the Supreme Court of South Africa, said no, that it wasn't necessary. He said the Constitution is the apex law, and we do not have to refer to the Constitution wherever it might apply. So the issue is that you still have to do the balancing test, because part of that balancing test is to ensure that you do not infringe on the fundamental rights, or in this case, the constitutional rights. Remember that not all of the countries in the European Union have constitutions, but they do refer to fundamental rights in dealing with that assessment. And in that context, obviously, privacy is a constitutional right. So you do have to balance when you're doing the legitimate interest test, what you're doing with the fundamental rights or the constitutional rights of a data subject. I hope that answers your question, Rafael.
Thank you, Mark. John, Nathan, I'm going to leave you to the end because there's a question that I really want to get to, and it's around, and it's more to you, Alison and Galani, around whether the regulator is planning to release an adequacy list, and when, and what should people expect there? What is the regulators thinking around that at this point in time?
Sure. So an adequacy list, what happens is that if you send data across the South African borders to another jurisdiction, the question that you need to be asking yourself is that data safe where I'm sending it? Because there's obviously no point keeping the data safe in South Africa and then sending it off to, I don't know, trying to make up the name of a country quickly. A made up country. If we send it to another country and then that country has no legislation and it just sends data everywhere and it allows data processing for any reason, obviously then you haven't kept the data safe. So what's the best way of doing that? And the way that, as is so often the case, the way the European Union does it is look for an adequacy finding in relation to another jurisdiction. So does that other country actually have legislation and measures that are in place in order to protect that data? So the data is protected wherever it travels in the world. And the way that works is that there needs to, let's say that there's a challenge and somebody says, well, this person is sending my data to Sutherlandia, which is my made up country, and Sutherlandia does not have adequate provisions for the protection of information. And the regulator would then have to make a finding in which they say whether or not Sutherlandia has adequate data protection provisions. Is there a list of countries that you can send information to? Is there a list of countries that you can't send information to? The answer is no. The regulator has not made those determinations. If you look at the number of countries that exist around the world, the last number I have is 187. There is not going to be a list of 187 countries and which ones are and which ones are not adequate. We're not going to be able to do it in that way. So we would be prioritizing it on the basis of complaints and then on the basis of the regulator's own process around adequacy, which is involving research around adequacy in jurisdictions, and we're tending towards jurisdictions where we have major trade links and that are big, a big part of our economy. So I think that's the way that's going to unfold as of now.
Thank you, Alison. And I see that we're just on the dot. So I guess my section is wrapped up. Just to remind you that we will be sending these questions over to the regulator, and some of them are also, we'll be dealing with them next week when we have our members only session. And so don't worry if we didn't get to you. We'll try to make, and the recording as well is available. We'll make the recording available. But from my side, thank you for the time, John.
Yeah, well done, Zokele. You did a hard job well. And just looking at the other questions that are out there, a lot of them, the answers are on the Michalsons website, like with regards to cookies, what's special person information, prior authorization, There really is, most of those questions are answered on the website, so I'd encourage you to go and have a look there. Yeah, but thank you very much for joining us. I really want to thank the Information Regulator, both Alison Tilley and Michalsons Dimba. Thank you very much for your time. I really appreciate your willingness to come onto a session like this and to share information and to answer questions. It really is greatly appreciated. And to Nathan Ross and to Mark and Zwakele, thanks very much for your time. And I think let's call it a wrap there.
Great. Thank you very much, everybody.
Thank you, everyone.
Thanks, everyone.
Thank you so much. Cheers.
Cheers.